Wagner, we'll hear from you.
Thank you, Judge. And may it please the court, good morning. My name is Rob Wagner. I represent Mr. Myrick on this appeal. The principal issue that Mr. Myrick presents before this court is the Speedy Trial Act violation. Had the court properly calculated the tolling of the speedy trial clock, the charge against Mr. Myrick from the initial indictment would have been dismissed. And that is the relief that Mr. Myrick seeks from this court today. Mr. Myrick submits that the determination, the Speedy Trial Act decision, rests on this court's findings regarding the 16-day period between the hearing on the motion to to suppress on January 24th of 2023 and the district court's written order of February 9th of 2023.
Let me ask you this.
Sure,
I
Judge.
understand that argument. The question is whether the court made the decision during the oral argument or left it open and wrote later.
Yes, sir.
And if it wrote later, then everything was timely. But it seems to me that there are a couple of other issues that might even trump that. The December postponement, if the December postponement satisfied law, that would also eliminate any challenge, right?
I think it's unclear because there were two continuances, Judge.
I know, the first one.
Right.
The first one, and when the court wrote an opinion and gave reasons. The second time, the court just recited the formula.
Good cause.
Yeah,
Yes.
right. But the first time, there was a broader explanation. And my question is, if that was adequate, then we don't have an issue, right?
I wouldn't agree with that, Judge, because...
All those days get knocked out, right?
Yeah, but it's unclear from the record how many days that would actually add to the tolling, and whether or not... So the district court judge made
64 days it adds.
I don't believe so, Judge, because I think that first of all, the government took the position...
November 28 to January 31.
Yes, but again, it's unclear. So a lot of that time had been excluded by the district court, or had been used to toll the speedy trial for different reasons.
Well, I know, but we're adding up days, and it seems to me if that continuance was justified or complied with law, it hurts you. The second question, neither party raised, and I want to raise it with you, is there was a superseding indictment filed in February which added 2 counts, the 2 gun counts. And the question I have is, we have some unpublished authority that says that restarts the clock. And I don't know if you're prepared to address that, but that seems to me might be a problem in this case too, if that were so. So go ahead.
Okay, so I understand your questions, and I am prepared to talk about the superseding indictment, Judge. It wasn't briefed, and I don't have a bunch of case law on that.
And if anybody's curious about it, I'd be happy to give an opportunity. I don't know where my panelists are on that, but a few days to give us some case law on that. But
Sure.
It seems to me that you have brand new charges, substantive, really substantial charges, 2 gun charges with mandatory consecutive penalties,
Right.
and they were asserted for the first time in February. It would seem, at least as to those, a clock would have to start again. Now,
Right.
then the question is, what happens to the drug count? And,
Well, and
I don't know the answer to that, but to me, I would think that if you add them, you have to start the clock again, just like when you add a defendant.
Right.
In order to protect the defendant, the others ride along with it. Co-defendants have to ride along with it. So it's sort of a black and white response to your challenge. If the superseding indictment that adds additional risk does restart the clock, then we wouldn't have to get into the question of whether the district court decided orally or in writing,
Right.
which is where you focus most of your attention.
Sure. I think the argument could be made that as to the 2 additional charges that were added, that the Speedy Trial Act did not apply to those charges.
I know,
but
we don't split up indictments by parties and counts when we're trying cases. If they're put together, we can take them apart or put them together.
Right.
In this case, they're put together, nobody's challenged. I mean,
Right. But I would argue, at least as to the original charge, that the superseding indictment would not have told the Speedy Trial Act or started a new Speedy Trial Act for that charge. That charge had been pending for quite some time at that point. But I would appreciate the opportunity to brief that if that is of concern to the court. I'd be happy to
check
do
with
that.
my colleagues here on that.
All right. But as to, I'm sorry?
Okay, so why don't you, each of you within 10 days, just give us a little simultaneous response, either by letter or brief, on the issue of whether a superseding indictment that adds substantive counts starts the clock again. I don't know if there's a lot of law. We didn't do a lot on that, but as you're going through the sequence in this case, it sort of raises its
Right.
raises it.
And
the other question, which I'd like you to address during your argument, is why the first continuance would not stop the clock.
Sure. And as to the superseding indictment, that was nothing that the district court addressed in its consideration of the issue. Right. But nor did the district court ever mention it as a reason why the speedy trial clock should have been told.
That's fair. I share that view with you. It just popped up when reading your
Sure.
briefs.
I understand. Let me address your first issue, Judge. So really there are 3 reasons why the court should not accept the position that continuance, that first continuance that was granted should toll the speedy trial clock. First of all is the authority on point. And I would suggest the Bloat case from the United States Supreme Court is directly on point. It dealt with the same issue, the filing of pretrial motions. And that was all that was placed on the record by the district court, was that the reason for this continuance was the filing of pretrial motions. Didn't go into any more explanation.
And then this was I think, during the period when new counsel came in and had to prepare.
That's true.
And the court gave several reasons. It used the formulaic in the interest of justice, but then it gave its reasons after that. And the question, I guess your argument is those reasons were inadequate. But it seems to me if we were to conclude they were adequate, then the Speedy Trial Act goes away, issue goes away, doesn't it?
Again, I'm not sure about the computation and calculation of days on that particular
I counted
motion.
64 days, but.
Yeah, I would disagree with that, but a lot would depend on the other decisions made by this court as to the second motion for continuance. But most importantly,
For the first one, was there an objection to it?
I'm sorry, was there an objection?
Was there an objection?
To the motion for continuance?
Yes.
No, Your Honor, there was not. The motion was, in fact, I think, made by the defendant in that particular instance, but I don't think that's determinative of the issue.
The second one was a joint motion, I believe.
It was a joint motion, correct? Yeah, but as to the first motion, Your Honor, the decision made on the motion for speedy trial to dismiss on the basis of the speedy trial, it was made on the 22nd of March, the first day of trial in 2023. And at that point in time, the district court didn't place anything on the record in addition to what was in his order that he signed granting the motion to continue. So for the district court to come back and give other explanations later in later litigation on the issue should not be considered by this court. It's what was decided, and that's the Smart case, that's the Hart case, what was decided at the time, what rationale was given, what justification was given for the granting of the continuance at the time the speedy trial.
Let's take the first continuance. The first continuance, we have new counsel coming in. New counsel wanted to file motions, New counsel said, I want to be able to represent this man, and I need more time.
Yes, sir.
And he filed a motion for continuance on behalf of the defendant. The court not only granted it with the formula required by statute, but then a second paragraph gave its explanation as to why that would be just and in the interest. Where's the flaw?
Okay, and there are a couple, Judge. First of all, the district court, and this court has been clear on that issue, the district court has to articulate the reasons for that continuance. That's a disfavored factor for a speedy trial.
A new attorney comes in and said, I need to prepare for the trial. I just got in.
I agree, Judge.
It's in the interest of the defendant, it's in the interest of the public, it's in the interest of good justice.
That may be a valid point, but it wasn't placed on the record by the district court as the reason for that continuance. You look at the order that the court issued on that particular continuance, and that order specifically said for pre-trial motions, for the filing of pre-trial motions, didn't say anything about considerations of new counsel and the balancing of interests for ends of justice reasons for the continuance.
That was advanced by the defendant. I mean, that's what's on the table.
Right, but this court has to be bound and has to pay attention and look at the rationale provided by the district court. I mean, the defendant can give all kinds of reasons for a continuance. The government can make all kinds of arguments on the record, but it is what the district court decides and what's on the record from the district court that controls the issue. And we have very little on the record before that initial decision to continue the case on that first continuance motion was made on the 22nd of March of 2023. And the other thing, Judge, in the government's own...
The court said in its order, it says, defendant's counsel has recently retained and has requested a continuance to allow time to file appropriate motions. And it seems to me there could be nothing more fundamental to the interest of justice, not only for the defendant, for the public, is to make sure the defendant has proper representation.
Yes, sir, but I don't believe that's sufficient to demonstrate that other than the filing of pretrial motions, that was the reason why the court, from that record, from that order, was ordering that continuance. He represented recent, but how recent? And to what extent was that particular issue controlling on whether to grant the continuance? And the other thing is, Judge, that the government in its pleadings, in its filings on the speedy trial issue, gave it a number of 62 days and never used that continuance in the filing of its briefs as a reason why the speedy trial clock should have been told. And so I think that's very important, that the district court in its findings found that 65 days, only 65 days, had been run off of the speedy trial clock. And so based on the district court's ruling of 65 days, based on the government's representations that 62 days had run, when you add that 16 days from the decision on the motion to suppress and the final order, the written order that was submitted by the judge, that 16-day time period, that governs the decision of this case. That governs this court's decision of whether the Speedy Trial Act was in fact violated. And I think focusing on that 16 days is important, Judge. I mean, we've gone to great lengths talking about how the defense attorney at the suppression hearing noted an exception to the ruling of the court.
There wasn't a ruling of the court. There was not a ruling of the court. Where did the court say that it granted the motion?
Well, at the time when the defense counsel said, I'd note my exception to what the court has done, the court could have done several things. It could have said, well, counsel, I understand you're noting an exception, but I want to take some time. I want to think about this issue, and I want to be able to take it under advisement.
So where did the court say it granted the motion in the hearing?
Well, I would suggest that by the court noting the exception by the attorney.
You mean the defendant noting the exception?
Well, the defendant noted the exception, and then the court noted the exception as well. It said, in the record, I note your exception, counsel.
So that you infer that that's a ruling.
I think it's more than an inference, Judge. I think if you look at Black's Law Dictionary's definition of an exception, it's an order of a court. It's a disposition of a case. And if basically the defense counsel is acknowledging that the case has been disposed of,
Right.
and then the judge goes ahead and notes that exception, I think he's
You'd have a
indicating.
stronger argument if there wasn't this later minute entry where the court says, I took it under advisement. And we're here, it's a factual decision, which makes your burden more difficult.
So Judge, the court doesn't operate under the minutes that are provided by the clerk
Right,
after
but
the
that's,
hearing.
in effect, evidence that we consider and looking at all the circumstance. And these determinations are factual determinations. Did it happen or not? And we have to say when the district court then entered its written order that they were clearly erroneous in making that determination.
I would suggest to the court that it's a mixed, as I put in my reply brief, that it's a mixed question of law and fact, and that the application of those facts to the Speedy Trial Act is very significant in this case, and brings in a legal question as to whether or not that exception ended the tolling period for that motion. The statute in this case, 3161, makes very clear, and the cases that construe 3161 make it very clear that that statute's to be construed very narrowly. And the cases from this court, the Bloat case, the Zedner case from the United States Supreme Court, all make it clear that the factors within 3161 and the construction of the speedy trial is to be construed narrowly. And in doing so, this court should dismiss at least the original count in the indictment based on speedy trial grounds.
Thank you, Mr. Wagner. Mr. Arnold?
Good morning, Your Honors, and may it please the Court. Daniel Honnold for the United States. I'll start where my friend left off with the motion to suppress continuance on the Speedy Trial Act motion, because I do think that is probably the most straightforward way for the Court to affirm on the Speedy Trial Act claim. I agree with Judge Agee's point towards the end there that whether or not a district court has disposed of a motion basically subjectively in its mind is a factual question that is to be accorded deference by this court. And here the district court repeatedly held...
Well, it would be objective. The court says, I grant your motion, and I'll document it following with a written order, which sometimes is done. But the defendant here doesn't rely on that type of dialogue. The defendant relies on the fact that the court noted when the defendant made an exception. He says, I note your exception, which basically means I'll take that into account or it's preserved. But it doesn't necessarily mean, I don't think, that the decision was predicted, but the question is whether the decision was actually made orally or was going to be made in a written document.
Yes, Your Honor, I completely agree. The dialogue at multiple points in the motion to suppress hearing, would you please note my exception, sure I will, and sure okay, are not going to be enough to show as a matter of law or that a district court clearly erred in later finding that when it had that exchange with the defense attorney, that it had actually ruled on the motion at that time. And I think the minutes shortly thereafter, shortly following the conclusion of the motions hearing, are really a strong indication of this. At that time, before any motion to dismiss for Speedy Trial Act violations was at issue, the minutes clearly reflect that the district court had taken these under advisement. And it, again, holds this at 1473, 1331, 1442, and 1465. Over and over again, the court is saying, I did not decide the motions to suppress at the conclusion of the hearing. Rather, I took them under advisement. And it specifically addresses the defendant noting his exceptions at 1473. It says, The court did not dispose of the suppression motions at the hearing, but rather noted defendant's exceptions and took the matter under advisement with an opinion to follow. That is a finding of the court that is to be accorded deference and subject to clear error analysis. I just heard my friend propose that it should be a mixed question of law and fact. We respectfully disagree that when a decision is rendered or adjudicated is an ascertainable fact about the world, it's a particular date. That is quintessentially a factual finding, but even if it were a mixed question of fact and law, it is a predominantly factual one under Bufkin v. Collins or Wilkinson versus Garland from the Supreme Court recently. When a mixed question is predominantly fact-based, you still apply the clear error or heightened deferential standard. And again, rejecting that factual dispute by my friend is going to be sufficient on its own to resolve the Speedy Trial Act claim, because all parties agree that tolling the days between the conclusion of the January 24 hearing and the February 9th memorandum decision denying the motions is going to be enough to bring the Speedy Trial Act clock down below 70. If the court has no further questions on that,
Thank you. Right.
thank you.
All right, Mr. Wagner, you have a few minutes.
Thank you, Judge. I would turn the court's attention to what I referenced in my opening brief and reply brief, the definition of an exception as provided by Black's Law Dictionary. Exception, as used in the context that the judge used it in this case, is an objection to an order or ruling of the trial court. A formal objection to the action of the court during the trial of a cause and refusing a request or overruling an objection, implying that the party
What if the court
accepting.
said, we don't disagree with the meaning. What if the court said, I'm going to deny the motion and do so in a written memorandum to follow?
Yes.
And defense counsel says, I have an exception, and the court says, I note that. Would that change?
It would make my argument much stronger, Judge.
Stronger. When the
Or
court says,
definitive.
I'm going to decide it in a written document.
Oh, I'm sorry, Judge.
My hypothetical is if the court said, I will be.
I am not ruling. I thought you said I am ruling.
I will be
I'm sorry.
granting the motion in a written document, which I'll get out shortly. And the court says, I want you to note my exception. And the court says, noted. That would change it altogether, right?
I believe so, Judge.
So taking an exception to something that either will happen or has happened, it doesn't change that at all. The defendant wants to note that his position stands.
Well, I think how we should construe that dynamic in the court at that time was here the defense attorney is listening to the ruling that the judge is making, the questions that the judge is asking, and at that time, I mean, he was clearly going against the defendant. I'm sorry?
Clearly predicted he was going to deny the motion.
Oh, yeah, and so the defense attorney, knowing he
didn't
had...
say he was actually denying, he was going to, and the clerk at the time, on the very same day, said the court took it under advisement.
Right.
And that's what the court itself thought it was doing, and then it issues its opinion.
Well, I would have to disagree with that construction, Judge, and simply point out that if the judge actually intended to take the case under advisement from that point and was not making a final decision, he should have told counsel that at that time. If I note an objection to a judge and the judge says, okay, I note your objection, counsel, I believe at that time that matter is resolved. And there's not going to be any further thought process and that decision-making process that in reaching a final decision. That was the prompt disposition of that particular issue by the district court at that time. And so,
I understand you're court appointed.
I am.
And as always, you did a wonderful job for your client, and I want to note the importance of your service in that regard. It's something we rely on heavily to make our system work, and you're a big wheel in that. We'll come down and greet counsel and then proceed on to the next case.
thank you, Judge.
Good morning, Your Honors, and may it please the Court. My name is Mary Beth Reed, and I represent the petitioners, Yamilet and her minor son. I'm joined today at counsel table by my colleague, Evelyn Smallwood. The record in this case reveals that Yamilet testified credibly to the fact that she and her family went to the police on at least 3 separate occasions and never once received help or protection. The record further confirms that the Salvadoran police were hampered by inadequate funding and limited resources, and that there was actual corruption within the police force. The record labels El Salvador as the most dangerous Latin American country for women. On top of that, the United States Department of State report confirms that laws against rape were not effectively enforced and that violence against women and girls was infrequently addressed by the authorities. Together, all of this evidence was ignored by the agency, and that was erroneous. I'd like to first start with the legal errors of the agency's decisions, then turn to why their findings are not supported by substantial evidence, and how ignoring all of this evidence is an abuse of discretion. So first, turning to the legal errors, there was a conflation of elements here in between what is the well-founded fear of persecution and government protection. And I'd like to clarify what we are and are not arguing here. This is not an argument about the order of the elements of asylum, nor is this an argument saying that there cannot be any overlap between the elements. Amaya makes clear that overlap between legal elements is very common, but what creates a problem is when one element is completely subsumed by another. And that's what happened here, where the immigration judge's analysis of government protection was completely subsumed.
I thought in this case, the appeal was taken to the BIA, and the BIA did not address all the elements. The BIA addressed only the police were unable or unwilling and relied solely on that factor.
That's correct, Your Honor.
Wouldn't that be the only issue before us today?
That's correct, Your Honor. And that is the element that I'm saying is completely subsumed within the immigration judge decision. And we see the same error made by the BIA as well.
You ought to reverse the order. The BIA is who we review.
Correct.
Yeah.
Correct, Your Honor. And so the BIA does the same mistake as well. And so they look only to...
Can you re-articulate exactly what you say the error is?
Of course, Your Honor. The error comes down to not applying the correct legal standard for government protection. Or when we say government protection, we're talking about the element having to do with whether or not the Salvadoran government was unable or unwilling to protect my client. And so the legal standard here is completely missing from both the BIA and the immigration judge analysis, and instead they're solely focusing on future harm to the applicant. Again, I think the reason for this is because they're conflating it with a well-founded fear of persecution, that they're only looking to the future.
You won't stick with the issue, will you? The one issue is whether the police were unwilling or unable. The BIA made one reference to it, and it seems to me suggesting there was no evidence of that. And your argument is that there was plenty of evidence because she testified on various occasions when she called the police, and they didn't respond.
That's correct, Your Honor.
And they didn't address that at all.
Yes.
Okay, but I don't know why you keep going into all the asylum and going back to the IJ and so forth. The BIA's opinion is very narrow. It did not go in all the other elements, and it did not go into blurring. It basically addressed the one element, were the police unable or unwilling.
That's correct, Your Honor. Even within that analysis, I think what's missing here is the analysis from this court's en banc decision in Portillo Flores, where the agency is supposed to look at whether or not it was futile for an individual to go to the police and whether or not that individual may have been at risk at further harm by going to the police.
So what do you say the standard of review is here?
The standard of review, I would say, for the legal errors is de novo, and then substantial evidence for the factual findings related to whether or not this evidence is adequate based on the holdings that the...
That's clear error. The BIA says that the respondent argues that the government's unwilling or unable to protect her, and that's a factual determination.
The factual finding of whether or not, yes, although they ignored the legal errors made by the immigration judge, and that should have been reviewed de novo.
All right, so help us understand what legal error relates directly to this factual question.
I think it's the incorrect legal standard, Your Honor, and so
All
in
right, so
particular.
tell us what that is in your view.
Yes, it's what I just mentioned related to Portillo Flores of asking whether or not it is futile or whether the individual is at further risk of harm. The immigration judge didn't have the benefit of this court's decisions in Orellana and Portillo Flores, but the BIA did, and they ignored that new standard related to government protection and failed to apply it here. In addition, we also think there is not substantial evidence to support the factual findings here, and I'm happy to jump into that as well.
So your argument is that below, you argued that it was futile for Ms. Chavez to go to the police?
It was not argued in the brief. Again, Portillo Flores had not been decided, Orellana had not been decided. However, the case was also not remanded back to the immigration judge in light of those new cases. But I do believe that based on the evidence in the record, that the fact that she and her family went to the police on at least 3 different occasions, never received help, would be evidence to suggest that it's futile to continue.
Maybe I've got this confused with another case. I thought there was a 5-year period where she didn't go to the police at all. And
There was a period of time where she did not go to the police. That's correct, Your Honor. But again, I think once you've already been to the police 3 times, including after having been kidnapped and separated from your family for an entire year, when the police is not willing to help.
so did they ever, why do you say they're not willing to help?
Precisely because of the fact that she went to the police at least 3, she and her family went to the police at least 3 times and never received any form of protection. So she presented herself in a variety
So
of crimes
the-
as well.
Are you arguing that if the police fail to make an arrest, that is sufficient in and of itself?
No, Your Honor. I think what more has to do is the fact that we have evidence that she went to the police and there was no follow-up of any kind. We don't have evidence in the record that the police tried to help. We don't have records of investigations. We have none of that here. All we know is that she went to the police at least 3 times and stopped going to the police
But
because they had.
There's no evidence that the police said, we're not going to help you, we're not going to investigate this, correct?
That's correct, Your Honor, and I don't think that's required. So Portillo Flores reiterated the fact that there is no per se reporting requirement. And so if an individual need not go to the police, I don't think that there can be a
Right.
requirement.
It may not be per se, but it is evidence.
Of course, Your Honor. But I think it would be helpful to contrast this case with Melina Diaz, which was the recent decision from this court that the government brought to this court's attention in the
I thought she testified when she complained on the various occasions that nothing happened. They didn't come.
The police did not come?
No.
Yes, Your Honor. My understanding, there was one time where she spoke directly to police, and they asked her who was it.
That's at the Salt in the.
Yes.
Okay.
She was beaten in public, and the police came and took.
And they didn't do anything there.
Correct.
But earlier, she said she'd called the police on various occasions, and nothing happened.
Correct.
And yet the BIA says that there's insufficient evidence that the government was unable or unwilling to control perpetrators in these crimes, including Abiud, and basically said that was a question of fact and didn't address it any further.
That's correct, Your Honor, and I think that there is not substantial evidence supporting the agency's decision. And importantly here, the BIA does not provide any specific reasons for their decision. We don't know what evidence they found compelling to support their decision. The only evidence that we have from the agency in general to support the fact that the Salvadoran government was somehow unable or unwilling to protect Yamilet comes from the immigration judge's decision, where he points to the fact that.
Why does it come from a decision that these are factual questions? They have to be in the record.
Well, but.
And it seems to me your argument has to focus on the record. Now, I did look through the record, and all the time she said she called the police, and she said nothing happened or they didn't come. Now, that was never addressed.
Correct, Your Honor. I would say related to an abuse of discretion, this court does look to the reasons the agency provides for disregarding credible, unrebutted testimony. And so I do think we need to look at what reasons the agency gives here, and it basically gives none. The only reason that an immigration judge could point to was that rape is criminalized and that there are restraining orders. But that cannot possibly be enough to go against all of the testimony and country conditions evidence that Yamilet did present here. And I think it's helpful to contrast this case with Melina Diaz. There, the police did actually help on 2 separate occasions. So the police did an investigation, they closed down a street, they looked into a murder, and also they provided security at a funeral so that individuals were able to attend the funeral and receive security and protection. That is in direct contrast with what we have here, where here, Yamilet and her family went to the police several times, never received any form of help. The police didn't come on several occasions. And I think it bears noting here the different types of crimes that they were going to the police for. She was kidnapped from her home at the age of 15, and her parents went to the police and they didn't, as far as we know, there is no investigation that was done there. Later, her partner was shot in the leg and there was no help from the police, and she was beaten in public. And again, they got the name of her abuser and still continued to do nothing to help support her. And in particular, Portillo Flores indicates that we have to look at the specific circumstances of the applicant, and that weighs most heavily when we're talking about whether or not the government is unable or unwilling to protect Yamilet. And so I think here, her credible, unrebutted testimony comes first in terms of how we look at this and how the evidence is weighed. And again, we have no reasons from the agency here. It is not a clear decision. We have, as Judge Niemeyer pointed out, the BIA decision is incredibly brief. They don't explain their decisions, and that is an abuse of discretion. And on top of that, there is not substantial evidence to support the facts in this case. All we have is the fact that Yamilet and her family went to the police, didn't receive help. Again, the country conditions only go to support this. The United States Department of State report also only helps support this. And indeed, the immigration judge cites to that, but he cites to the fact that only 5% of 6,000 something reported crimes ended up going to trial. But that only helps Yamilet. That helps prove her point that there is not adequate protection in El Salvador for gender-based crimes. And all of this together shows that there's not substantial evidence to support these decisions. And again, because they did not offer any specific reasons to disregard Yamilet's unrebutted testimony, we do ask that this court would grant the petition for review and remand. If there's other questions, I'm happy to answer, but otherwise I can reserve the rest of my time for rebuttal.
All right, thank you.
Thank you.
Ms. Henley?
Good morning, and may it please the court. Madeline Henley for the Attorney General. The only question before the court is whether the record compels reversal of the agency's conclusion that petitioner presented insufficient evidence to show that the government of El Salvador was unable or unwilling to control her non-governmental persecutor, Hernandez. It does not. And I'd like to skip, based on what my opposing counsel focused on, I'd like to skip directly to her repeated assertion that that petitioner testified on three separate occasions she reported her harm from Hernandez to the police, because what the record actually shows is that she says that she did so on various occasions, but the record does not support that. The record supports a single report where the police came to her assistance. The first page.
No, it's not correct. She testified, I have it listed here, she testified several times. She said, I called them on various occasions, and she talked about, repeated that type of testimony, and they would do nothing, and did nothing. And then the one incident where the police were there, they did nothing. That's the one you're referring to. But I think you're just overlooking her testimony.
No, Your Honor, I'm sorry, I disagree. I'm not disputing that she testified that she reported on various occasions.
And she said nothing happened.
And she said nothing happened. Yeah. And my point is that is not substantial evidence.
Why not?
Because simply saying, I did it on various occasions without specifying that
she did specify on two. She talked about two different earlier occasions when she called the police.
Your Honor, on the first page she cites where she says various occasions is 119. And there she was specifically asked whether she was age 11, it was 2002, and she claims that Hernandez and his other gang members who came to the house and beat her up, her father, and her siblings. And her attorney asked her, "Did you report this to police?" And she answers non-responsively, "I did on various occasions, but nothing happened." At this point, 2002, she's 11 years
She was
old.
asked again later. She said many times she went to the police. She said when her uncle and cousin were killed, and it was all in the news, nothing was done by the police.
She actually, with respect to the uncle and cousin, she also does not say the police was reported, and she said no witnesses wanted to assist. Your Honor, I really want to point out, because
But my point is not, the question is that was never assessed. The IJ said simply, respondent has not provided sufficient evidence to conclude the government was either unable or unwilling to control Abiud, and that's all it says. It doesn't take up any of the evidence, it doesn't take any of the country response, and then that finding, which doesn't address any factual matter, the BIA says we accept it, and that's it. 2 sentences, one in the IJ and one in the BIA, and the question is, how does that address her claim that the police were unwilling to help? Now, you can say it wasn't specific, you can argue that it was this or that, but there's plenty of evidence that the police weren't doing anything in response, and the suggestion was that it was domestic violence, and of course she maintained the entire time that she never had a relationship with him, that she was a sex slave. She was stored in a room for a year, locked into a room and fed and raped, and finally had his child, I mean, this evidence isn't addressed by the IJ on that issue.
Your Honor, the harm that petitioner in her account is harrowing, but the record reflects she specifically denies that she reported the abduction and rape by Hernandez that occurred between 2005 and 2007. She said, she was asked, "Did you report that?" She said, "Not on that occasion." She then testifies at page 168 of the record that the report at the fair, when she was harmed, she was assaulted by friends of Hernandez, and the police came to her assistance. She says that was the last report she ever made. That means
Where does any of this appear in the IJ?
The IJ summarizes her testimony fairly as, "I reported on various occasions and they did nothing." That's an accurate assessment because she didn't report she didn't specify any occasion on which she actually did report. She never, and the only time with respect to the fair in 2007, which was the last report, she says that was the last report she ever made. And at that report, the police came to her and they said, and she says she told them, "I believe Hernandez was behind it." She doesn't say, she was 16 now. She doesn't say what was the basis for her belief that Hernandez was behind it. She doesn't say what she told them. She doesn't say if she said where they could find him. She doesn't say if she described him. And she doesn't say how she knows they did nothing. Just saying they did nothing. In the court's other cases, they have cases where the petitioner went back to the police. They followed up. Here,
But, Judge Niemeyer's point is about, this case is more about what the IJ and the BIA do not say and do not address. They do not address in their opinions any of her evidence that the police were unwilling or unable to assist her in any meaningful way that we can review.
Okay, with respect to the immigration judge does assess the record as a whole as only establishing that she says she did it on various occasions and they did nothing. But that is a thin record with regard to this reporting where there's no specific testimony beyond the one incident of the fair where and in addition, where there was no corroborating evidence.
What is it you're saying that petitioner would have needed to have done?
Petitioner, first of all, she needs to make contact with the police, right? And so here, there's only evidence that there is some, I'm sorry, may I just take a sip of water?
Oh, certainly.
petitioner needs to have established that she reported her harm to the police. Absent the evidence of reporting, of informing the police that this is happening, it's not meaningful to say they did nothing because we don't know what they knew. Here, there's evidence of a single time that she spoke to the police when she was harmed by friends of Hernandez, and a denial that she reported any of the rape or the abduction. She denies she reported it between the 2005-2007. She says 2007 was her last report,
So you're
and the
saying
other
that
rape occurred in 2014.
I'm sorry, so you're saying that in the government's reading of the record, she only reported to the police one time?
Correct. And in addition,
The
with
IJ
regard to
just
the
really,
board,
discounted it all simply because she didn't file police reports.
not
that's what
simply because she didn't file police reports, because
Despite the horrific habitual claims or abuse for years and claims of reporting to the police on various occasions, respondent provided no evidence of police reports relating to abuse. That's how the court disposed of it.
correct. the
So is there a requirement that a police report has to be filed as opposed to calling the police and complaining?
There's absolutely no requirement that the police report per se. However, this case is not about futility of reporting or about
No, I'm suggesting to you, I'm not suggesting to you that the evidence would survive or not. What I'm suggesting is that the evidence she put in was just not considered by the BIA. The BIA basically said, well, the IJ made it a question of fact, and when there's two different positions, we go with the BIA. We go with the IJ. And so you look at the IJ, and the IJ basically says, well, she didn't file police reports. And so that's the reason.
To me, the IJ says that that she reported that she did it on various occasions and they did nothing. But her testimony is very thin. There is nothing more.
Not the question is whether it's thin. The question is, what did the IJ say about it? The IJ rejected it because there wasn't a police report.
The IJ rejected it because, in addition to the fact, there's nothing more here in this record to show that it was done. There's no police report. Her mother submits a letter, doesn't say that she or the family reported. The police submitted.
What did the IJ say about it? I don't want to keep hearing what the record shows and your views of the record. We're reviewing. My only trouble with this case, you may be absolutely right. My trouble in this case is the BIA gave one sentence to the issue, dispositive issue in the case, that the police were unwilling or unable to come. And the record shows that she made a point several times that they were unwilling and unable to come. And now you're attacking her testimony, but the IJ didn't address that except to say she never filed a police report. And then it moved on. And so the question is that adequate? And is BIA adequate in just accepting that without looking at the record?
Your Honor, let me address the board decision. The board recognizes the immigration judge's decision that her whole claim could be denied for lack of corroboration, then the immigration judge's decision that she failed to establish the unable and unwilling prong of her claim. And then the board looks to the petitioner's brief, and the board says, this question, whether or not the government is able to control the non-governmental persecutor, is a question of fact that we review for clear error. Petitioner contends on appeal to this court that her testimony and the country conditions evidence should have been enough to establish her burden. That contention does not show clear error in the immigration judge's.
Who said that?
The board. That's exactly the basis for the board's decision. The board says this is what she contends on appeal.
You talking about at JA 4?
Correct. Petitioner's
fourth paragraph
contention
on
that
the
her
page.
testimony and country conditions is sufficient to meet her burden does not suffice to demonstrate any clear error in the immigration judge's finding. We're
The
here.
immigration judge finding was that she didn't file a police report.
The immigration judge's finding was that she testified that on various occasions she
Yeah.
reported to the police and they did
And
nothing.
they accepted that apparently but they said it's not enough because she didn't file a report. That's the
They
next
said it's
sentence.
not enough. That plus the country conditions evidence, which the immigration judge reasonably found were equivocal, and the fact that there was nothing more to bolster her claim. Just coming to court and testifying, yeah, I did on various occasions, but they did nothing, and then denying, in addition, that you reported either of the central incidents of harm.
What else is it the government thinks she needed to do? When you concede that she's not required to present a police report.
She's not required to present a police report.
I also don't think the police would put in their report, she reported to us, but we're unwilling and unable to assist. So I don't know what it is the government expects her to do here.
Your Honor, the court has a case where petitioner repeatedly attempted to contact police but was unable to do so. I'm trying to remember which case it is, but they talk about how she tried to call the police and they didn't answer, and they didn't answer, and they didn't answer, and then she went to a neighbor, and the neighbor tried to call the police, and the police didn't answer. And then a gang member found out that she reported to the police and threatened her, and so she didn't report again. And the court found she didn't do enough. She didn't sufficiently avail herself. Here we have of her own government's protection.
But
I think it's Larios Vargas.
The point that my colleagues are making is that had the IJ and the board written in their opinions what you've described, this might not be an issue. It's not that petitioner's going to prevail or you're going to prevail. I think it's more a question of sufficiency.
But the question is whether the evidence in the record compels reversal of the conclusion. And the conclusion is that she was insufficient.
Let's just stick to the one issue. This is what the IJ says in title in its analysis, not how it summarized the cases or the brief. This is its analysis on that issue. It says, it cites a case, and then it says, by contrast, respondent did not submit it. Oh, no, it says, third, respondent has not established that the Salvadorian government will be unable or unwilling to protect her from harm in the future. It cites a case which goes the other way. And it says, by contrast, respondent did not submit any police reports. Despite the horrific and habitual physical abuse for years and claims of reporting to the police on various occasions, respondent provided no evidence of police reports relating to Aboud. In light of the evidence submitted, and then it goes on and says it's not enough. And so it relied entirely on the fact that she had not submitted police reports. And then the BIA comes and says these findings of fact are not erroneous. And the question is, we all agree it's not erroneous because she did not file police reports.
Your Honor, it says the immigration judge said, in light of the evidence submitted, her evidence that she submitted, that's all of her evidence. The immigration judge clearly considered all of her evidence, including that she says she made various reports. Petitioner presented evidence that the police arrested Hernandez and he was in jail at some point. She presented evidence that at the time in 2011 when they came to her house and they wanted to abduct her, they didn't do it because neighbors they were afraid had called the police. The immigration judge was not persuaded that there was enough evidence here that she had actually contacted the police and they were unable or unwilling to do anything. And Your Honors, I would just also mention that petitioners mentioned here in their argument that this case, and they cite Portillo-Flores, this is a case where there's futility and that case was decided after and the court should have considered it. Petitioner's opening brief doesn't mention futility. This case has never been about futility. The case has been about her claim that she reported this many times to the police and they did nothing, and the lack of evidence to support that assertion in the record. Therefore, there is no evidence in the record to compel reversal.
Well, what do we take her testimony to be? Isn't that evidence?
Yes, her testimony is simply, I did it and they did nothing. That is the part that's insufficient. And in her brief to the board, she simply claims that the immigration judge should have found that her testimony and the country conditions was sufficient, but she doesn't identify any evidence that the immigration judge overlooked. She doesn't identify any supposed error of...
Does the IJ rely on country conditions in its disposition?
Yes. At page 94, the immigration judge relies on, is it 194?
94 or 194?
It's at 94 of the immigration judge's decision. In addition to her testimony...
It's where?
Page 94 of the immigration judge's decision, the paragraph finally.
Do you know what page of the appendix that is?
I didn't think.
94 of the joint appendix, I'm sorry.
Okay, so it's page
16 of the
16.
decision, 94 of the joint appendix. The immigration judge looks, this immigration judge looked at all of the country conditions evidence. It cited repeatedly multiple documents throughout the decision, and carefully considering all of it, reasonably concluded that the evidence was equivocal, and that while El Salvador criminalizes and prosecutes, and indeed the evidence shows that it requires that rape be prosecuted.
Can you tell me or show me where you're talking about on 94?
Finally, respondents submitted evidence that societal norms and
So
prosecution...
which paragraph
It's
are
the
you
paragraph that
second.
starts finally. It's the first full paragraph
All right.
on the page 94 of the joint appendix. While the effectiveness of the government's efforts to curb domestic violence and gang violence is an open and ongoing question, she's not provided...
And it also says, while laws against rape were not generally enforced, with only 5% of the crimes reported against women going to trial. I mean, that doesn't sound helpful to your side.
Correct, but it shows the even-handed view of the immigration judge. He's saying it's equivocal. We have that it's criminalized, but we have that there's evidence about ineffective enforcement. On that specific statistic, petitioner makes much of the fact in the opening brief that that evidence is not in the record. It is in the record. It's at the country conditions report at page 16, which is cited in the previous sentence. So perhaps the immigration judge should have had an id there, but it is definitely in the record.
The report says societal norms and prosecutorial impunity are a problem in El Salvador. That's what the court relied on. That's hardly addressing the government conditions. And it says, further respondents submitted evidence of widespread gang violence in El Salvador. Those two things don't focus on whether the country is unwilling or unable.
Correct, but the question is, what evidence did she present to show that it is unwilling and unable? And the only record is about the lack of sufficient effectiveness of rape prosecutions. But just because the government...
Well, I wish it would have been laid out. You know, you may be absolutely right. It's just, it's very difficult to go through this, especially when she describes these horrific events. One argument was that the police don't respond generally to domestic relations problems, and she protested throughout her testimony that this was never a relationship, that she was forced into this relationship, and said that she was basically a sex slave. And she said, I want to make clear I never had a relationship with Aboud, a voluntary one.
I'm sorry, Your Honor, may I just address that last
Of
point
course.
you made? Because on page 289 of the joint appendix, she says, I have been a victim of domestic violence since I was 14 years old. She said at her credible fear interview that she referred to Hernandez as her ex-boyfriend, so it's not accurate that she has never characterized this as a case.
No, I'm talking about Aboud, her relationship with Aboud. That's the problem. Aboud is the one that put her in a room, locked her up.
Hernandez, I'm speaking about the same person.
Oh, same person, yeah.
Same person, I'm just using his
Well,
last name.
She did explicitly say she never had a relationship with him. She never considered him her husband. She said, well, we can debate this, but it doesn't seem to have been addressed, these claims, giving her the benefit of the doubt of trying to explore whether the police were unwilling or unable. And I found it hard to decide what's going on. Now, you've made very effective arguments this morning, but it would require going back and seeing what she testified to. But she did testify to a very frustrating life where she was forcefully subjected to, she said, rape and constant rape and being locked into a room, and she called the police and they wouldn't respond, and this type of frustration is the type of stuff that has to be addressed, I think. But anyway, I understand your point on it too, very much. Yeah, all right. Reed?
3 brief points, Your Honors. First of all, Yamulet's testimony in this case was found by the immigration judge to be credible. We cannot ignore her testimony with claims that it might be thin or not fully developed.
Say that again. You say her testimony was or wasn't found to be credible?
Was found to be credible, Your Honor. And so because of that, we cannot disregard her credible testimony with claims that it might be thin or may not have explained in the best possible way all of her attempts to go to the police. What we do have is evidence on page JA 163. She says, I did go to the police many times. On page 119, I did go on various occasions, but they never did anything, they referring to the police. The government in its brief recognizes that credible testimony with the addition of Department of State reports is enough and that it is legally
The
sufficient to
government,
find.
in its argument, I believe, said that she testified that she only reported once to the police, but your recitation of the record would undercut that.
That's correct, Your Honor. We disagree with that. We know that the police came to her on one occasion when she was in public and was physically beaten, but she does still say in her testimony, which again is credible, that she went to the police on several other occasions. We know her family went to the police. We know that her partner Danny's family went to the police, and those other instances cannot be disregarded simply because we don't have a physical police report.
What is the evidence in the country reports that focuses on this particular issue? What does the country report say about the ability or willingness of the government to respond?
I think it firmly is in our favor and shows that the government cannot help. So it says, again, like
Where does it say that? What's it say?
Oh, so the specific pages. We have on page 245 of the record, services for victims of rape are very limited. On page 250, police are hampered by inadequate funding and limited resources. There's actual corruption within the police. Page 272, there's hundreds of femicides annually in El Salvador. Rape increased 18% around the time of Yamulet's individual hearing. So there are a lot of facts that back up her position. And again, the court doesn't...
That's true, though, for almost all the Central American countries and some in South America.
That's correct, but I think here what we don't have is the agency providing any reasons to go against her credible testimony in all of those country conditions reports. The only thing the immigration judge mentions is that rape is criminalized and there are restraining orders. But in Oriana, this court explains that evidence of empty or token assistance...
Is there any evidence in the record that she ever sought a restraining order?
There's not, Your Honor. So the fact that that relief exists, though, is not enough, and Portillo Flores says as much. A similar situation there, the immigration judge had pointed out that El Salvador was working towards combating gang violence and that they had prosecuted and arrested a few people, but this court specifically said that is not enough when we compare it with the specific circumstances of the applicant. And here, those specific circumstances are her credible testimony that on various occasions she and her family went to the police and never received help or protection, and that is enough. And the fact that the agency ignored that and on top of that did not provide sufficient or really any reasons.
What is it that you ask specifically for as relief?
We would ask that this court grant the petition for review, find that there is not substantial evidence to support the agency's findings.
Why would we do that? Why wouldn't we just send it back and tell the board or the IJ or both that they have to re-examine the record and make an explanation that they didn't make here?
I think that's another way to do it, Your Honor. I do think the record has enough here to show that there is no substantial
then we'd become
evidence.
fact finders, wouldn't we? We
Correct,
don't want
Your
to be fact finders.
Correct, Your Honor. But this court has said that either remand or reversal is sometimes the appropriate action, but we'd ask that this court remand back in favor.
All right.
Thank you, Your Honors.
All right, thank you. We'll come down to Greek Council and take a brief recess.
The Honorable Court will take a brief recess.
The next case we'll hear is Orellana versus Bondi, and Mr. Moravec.
Good morning. May it please the court. My name is Joseph Morvek on behalf of the petitioner. Here the board clearly violated 8 CFR 1240.21 and its own memorandum 1704. That violation concerned substantive rights and prejudiced Mr. Zelaya, leading to his removal from the United States. Under Accardi, this court should set aside the agency's actions, vacate the board's decision and the IJ's second decision, and remand to the agency. So addressing each of those in turn. First, the actual violation. The plain language of the court's memorandum, 1704, requires that an immigration judge's decision, once reserved to comply with the cap, granting cancellation.
It's not altogether clear to me that Judge Hong entered a decision or a final decision. It sounded to me like she was deferring until a date would come and then would enter it. Now, it may be that the normal practice is to enter a decision and then reserve it, but I was looking at the record there, and it looked to me like she did not intend to enter a decision at the hearing. What's she say there at the end?
At the end, she says, I will grant, but I have to reserve it until that visa becomes available. She does, I agree, the record does not contain a written or transcribed decision from Judge Hong, which 1704 required her to do.
She doesn't seem to want to. She said, I will grant, but she was referring to when it comes time for the date. But she basically said it's everything I do, right, everything is conditional, and it's telling him he's got to stay out of trouble. I question, I'd like to look at that again, but I'd question whether she even entered a decision at that time.
Yes, so the normal process is that an immigration judge has an individual hearing, makes a decision at that time.
Well,
and
they
says,
can, but I mean, the question is whether this immigration judge did.
Well, if the court...
What if the immigration judge in the middle of the hearing says, well, we've got one more witness, the witness is delayed, we'll go to tomorrow, and the judge says, well, let's wait until we get a date, and then we'll hear the last witness. If the judge did that, there would be no question, right?
Well, the judge couldn't do that.
Why?
The regulation and the memorandum don't create the priority date for the visa until the judge says the hearings are final. I have made a decision whether to grant or deny.
I know, but why does the immigration judge have to decide on that date? Can't the immigration judge postpone?
No. The regulation requires that the judge make a decision now. Under the old regulation...
Well, what if the immigration judge doesn't?
The immigration judge has to, in order
I
to
said,
create...
what if the immigration judge doesn't?
In order for the regulation to come into play and a visa to even start calendaring for the respondent, the judge must decide. If the judge doesn't decide, then proceedings are simply not over. The judge hasn't had enough hearings.
Did Judge Hong know at the time that the hearing was being conducted that there was not an available number?
Yes. In fact, all judges who operate now know that there are no visas available currently unless somebody is detained.
And my recollection is that she also noted that the government was going to note an appeal, future tense, and that when she instructed the petitioner about the need for good behavior, I thought she said something to the effect of, you know, if you mess up again, I'm not going to be the judge who looks at that. Is that correct?
Yes, but that prescription to him only applies until that visa becomes available. Once it's available, the regulation and the memorandum require the court's decision to be issued
All right, so now
within
what,
5 days.
I understand the argument based on this memorandum, which the government argues is just procedural, but what specific regulation do you say requires this?
Yeah, so the regulation governing how the immigration court handles the cap is 8 CFR 1240.
How the immigration court does what now?
How it handles the cap. So the cap is, Congress creates cancellation of removal as a form of relief, but says only 4,000 visas are available every year. There are necessarily more than 4,000 cases that the immigration court would like to grant every year, and so there's a backlog. That cap on 4,000, how the agency manages that backlog, that's what the regulation 1240.21 attempts to manage, and says those decisions denying cancellation will be issued the day the judge decides. Those people have the right to appeal, go through and handle those cases. If we're going to grant, the judge says, I'm going to grant this case, put them in line right now, create that visa number, create that priority date, not just as of the date, but even the time is required. Because if somebody was granted in the morning, somebody else in the afternoon, the court wants the specificity of knowing who's in what order.
So is it your view of the regulation that once the initial IJ had the hearing and indicated that they would likely grant the withholding of removal, that gave the petitioner an irrevocable right to have the number accorded and the withholding of removal granted?
Yes and no. It gave him an irrevocable right to that priority date. That date began on the day she made the decision. He does have an irrevocable right of the regulation and memorandum being enforced. Once the court knows that that visa is now available to him, he has met his burden. As to every element, the court then has a constitutionally available visa to him, and then is required by its own policy to issue that decision within 5 days.
But does that policy apply to new IJs?
Yes.
I thought the Section 9 applies to new IJs and not Section 7.
Well,
Why does it apply to new IJs?
Yeah, Section 6 and 7 apply to the 5-day requirement that they review and issue a decision. Section 9 says a new judge can make a different decision, but it's silent as to the timing. But Section 8 says and confirms.
So then a new judge here did make a different decision, correct? And Section 9 also says that the new IJ must familiarize themselves with the record, correct?
That's correct, and that's what the board said too.
And here is the record 1,000 plus pages?
That's correct.
How is an IJ, the newly assigned IJ, supposed to familiarize themselves with that sort of record with all the other work they have within 5 days? That's probably why the section on newly appointed IJs doesn't have a 5-day requirement.
Well, I would say no, and for a few reasons. First, Section 8 makes clear that the court administrators create a system where these deadlines are supposed to be adopted regardless of the procedural manner in which it comes before the court. This is supposed to be issued.
You said what, Section 8?
Section 8, that they are drafted with the deadline stated in the OPM document, regardless. So that's one. Two, the 5-day deadline isn't reviewed here for reasonableness. The 5-day deadline is imposed because that's the requirement the agency imposes on itself, and it reflects this extreme form of relief.
So under the facts of this case, I take it your position is that based on the language of the first IJ's opinion, you've already told me you consider that to be an irrevocable right, but that IJ's not there anymore, so you have a new IJ. So under your theory then, Section 9 simply doesn't apply?
No, Section 9 does apply. It's an irrevocable right as to that priority date. It's not an irrevocable right as to the ultimate decision. I'm not saying that if a new judge was assigned properly within the proper time.
If that's the case, what's wrong here?
Okay, so on January 13th, January 13th, 2023, that's when the immigration court knows that a visa is available and the background checks are clear. At that point, Mr. Zelaya has met his burden as to all the elements that are required, and the immigration court's self-imposed deadline says we have 5 days to issue the decision, which should already exist. The newly assigned judge at that time has 5 days. Reasonableness aside, like the court can't The agency has determined we have to issue this decision within 5 days.
But, and hadn't he obtained a new criminal charge by the time that the
Yes.
number came up?
And so that's where we get into this. The problem here is that the immigration court did nothing as of January 13th. That 5-day timeline doesn't run. It's not assigned to an immigration judge. 2 months later, the Department of Homeland Security realizes he has this charge which fell well outside of these timelines. They move to recalendar, and the assistant chief immigration judge at that time says, wow, we realize this change, we'll recalendar and start this process over again. But if they had followed the procedure and required that in 5 days that decision be issued, reviewed or not by a new judge, that should have occurred by January 19th, 2023.
Let me ask you, go back to my question. I've got the transcript here in front of me, and the very last line, the court, this is Judge Hong, goes through and basically says, I'm going to go along with you, basically. I'm going to give you a chance. You're going to have to stay out of trouble, and I may not be around when the decision's issued, basically, but you're going to have to stay out of trouble. And then she says at the end, proceedings are continued until cancellation number becomes available. Now, it sounds to me like she never got to the decision. And so my question to you earlier was, your only response is she was required to do a decision, but what if we conclude she didn't?
Yes, so Your Honor, what I'm suggesting is that the fact that a visa number was created for him, that he was placed into that queue.
No, I want you to construe help me construe what Judge Hong was doing.
Yes, that's what I'm saying, is exactly what she did. She had to have made a decision because the visa was
I know she had to. You're telling me the regulation, but she did not think she had to make the regulation. She basically kept talking conditionally, and she talked about how he's going to have to stay out of trouble to get his relief, and that there may be a different judge. And she said, this is very much in your hands right now, okay? If you want to stay here with your daughter or whatever, you're going to have to not get into further trouble with the law, because for her sake, and I wish you the best of luck, proceedings are continued until cancellation number becomes available.
Yes, until
And
that
she
number
also
becomes
said
available.
a different IJ would not be likely to grant his
Yeah,
application.
right.
If he got into trouble during the relevant period of time. The question isn't whether he got into trouble 3 months after the court was notified that the visa was available. Between the time that she made the decision to grant.
I understand. You know,
and-
I'm trying to start with a hypothetical you're unwilling to accept. The hypothetical is if she did not make a decision. You said she was required to, but it looks to me like she was very tentative. What if I construe that to mean she did not make a decision? What is the status now?
Yes, I understand the hypothetical. What I'm saying is it's not an impossible, because the regulation just requires it. The fact that a visa number was created, that can only happen when she made a decision. Therefore, she did
But
make
it
a
didn't,
decision.
the number, she put in for the number.
That means she made a decision.
But
You
she
can't
didn't.
put in for a
I'm
number
assuming she
without a
didn't.
decision either way. There had to have been a
Okay, here,
decision.
let's assume this. She did not make a decision, but she put in for the number and continued the hearing. The hearing is still open according to her.
It's unlawful. The regulation.
Okay, so now what do we do?
You have to correct that violation. That's what this court is here for.
And how are we corrected? We can't make Judge Hong's final decision for her.
No, you can vacate the board's acceptance and send it back to the agency. The board simply says, this regulation is not binding on us. That's their defense.
You send it back to the board now. If that's the relief you want, we can do that. And if we do that, he's not going to get relief.
Well, he is going to get relief, and that's where what I've asked this court for, and what I would ask the board on remand for is that
You want a gotcha. In other words, up to 5 years or 4 years or whatever, he stayed out of trouble. And then a few days after the 4 years were up, he got into trouble, but there's still no decision. Now you want a decision made as of the 4 years and not the full history of the thing.
Absolutely. That's what the law requires, is that his visa was available, he had met every element, and on that particular date.
I don't see how we get that out of the regs and how we create that kind of manipulation, right?
All right, well, I'll step back through. So the regulation requires that these decisions, when a judge is going to grant and
But
indicates
you
she's going
have
to.
to start with the proposition that she went after the number without having made a decision.
I have to start with the proposition that in order to get the number, she had to have decided she would grant and entered that decision into the court system.
What is the mechanism for getting a number? It's just, an email or a phone call, or what is it?
So that is an internal
It's
procedure.
internal,
There's
but what does she do to get the number?
My understanding is she communicates that to the court administrator.
Okay, so
and
she communicated to the court administrator, we're waiting for a number.
she would have to communicate, we're waiting for a number because I'm choosing to grant.
She didn't say that. She said, she says, I've heard this case, we're now waiting for a number.
No, she
And
says,
they granted
I
her,
will.
they gave her a number, right?
No, she says the words grant. I will grant this case. That's in her
I
statement.
understand
to
that
give.
was her intention, but she clearly did not intend at that moment to enter it.
No, she intended it for it to be granted.
She
It
continued the
has been-
hearing, and she said it's up to you, basically telling him that whatever she does is contingent, because her call was a very close one, she said.
Yes. It's contingent on that visa becoming available, and then once that visa is available, that decision that she's made to grant is entered. That occurs on
So
January
under
13th.
under your view of the case, I take it, you think that once this first IJ says, I'm inclined to grant this, at that point, there's an irrevocable right to get the number and mandate a decision with 5 days of the number.
Yes.
So her discussion after that I'm continuing this, you have to stay out of trouble, all that becomes irrelevant?
No, it's relevant, and that's what footnote 6 of the memorandum contemplates, is the Department of Homeland Security runs background checks when that visa number is available, and if they determine there's additional criminal history, they can recalendar it and decide. That was done here. The Department of Homeland Security says on January 13th, 2023, there is no relevant new criminal history. Go ahead and issue your decision. The relevant time here for Judge Hong's decision, her admonition to stay out of trouble, exists from the time she says I'm going to grant until the time that visa becomes
What's the
available.
purpose for granting the new judge additional time?
There's no additional time granted to a new judge. You simply have to have a judge enter that order at the time that visa is available, so it can be assigned to a new judge. They can review that
There's a
decision.
requirement that the judge familiarize themselves with the record.
Yes, the agents, it's very clear, and I want to make this point to the court. The agency did not disagree with Mr. Zelaya's construction of 1704 as far as the timelines that we are arguing are concerned. The board did not say that new judge doesn't have to make a decision within 5 days. They have a reasonable or an open amount of time to familiarize themselves
What
with
if
the
we
record.
conclude
They said-
then, in this case, a decision wasn't made and the number was requested erroneously because she did not sufficiently communicate the fact she had not made a decision? What's that lead to?
Well, if the court were to find
If we conclude that she did not make a decision and that she was not entitled to request the number because she had not made the decision, but she nevertheless requested the number and it was given, now what's the status?
I would say that that's not reflective of the record before the court. And
That
so
isn't,
that's
that isn't accepting my hypothetical, that's rejecting my hypothetical.
Wait.
My hypothetical is she did not make a decision and she knew she didn't, but she requested a number and the number was issued.
I guess to the court's hypothetical, that would require an additional layer of unlawfulness by the agency. It wouldn't obviate the second layer of unlawfulness.
Why don't you answer my question, what happens if we were to conclude she did not make a decision and she requested a number improperly, as you point out, because she didn't make a decision, she's supposed to only request a number after she makes a decision. And she requested a number nonetheless, and the number comes, and there's still no decision. No decision is made when the number comes. What do we do now?
You should vacate the board's decision. You should vacate the IJ's decision, Judge Choi's second decision, and remand it to the agency so a decision could be made as of January 13th or January 19th, 5 days after the visa became available to him.
So
Under
under
either
that-
scenario, either hypothetical, that's
Under
the
that
result.
circumstance, then there would be no consideration of this later criminal act.
No.
Okay?
Okay, I think we understand. Sort of involved here with the internal operations under these procedures. All right, Mrs. Aldana?
Good morning, Your Honors. May it please the Court. Sir Aldana on behalf of the Attorney General.
Keep your voice up, yep.
The government asked the Court.
You might want to move the mic a little closer to you.
Is this better?
We're across the room. We're
Okay.
about 25 feet from you, so.
Okay. The government asked the Court to deny the petition for review as OPPM 1704 is not binding, and the agency did not violate its own regulations or procedures.
Is
Petitioners
that as
argue.
loud as you can speak?
I can go louder.
You can speak louder than
Okay.
that.
Petitioner's arguments regarding the plain language of OPPM 1704 are premised on misstatements of that memo. This case was a reassignment case, and so therefore Section 9, page 5 of the memo would apply. And the reassignment process has no timeline, no deadline, as well as the review process for the newly assigned immigration judge has no timeline or deadline. Additionally,
So
petitioner.
opposing counsel says, as I understand his argument, that once this number became available and the first judge was no longer there, that whoever the new judge appointed was, they had to enter this order within 5 days regardless. That's how I understand their argument.
Correct. And that's what we're saying is a misrepresentation of the memo. That 5-day instruction is for the original drafting immigration judge. If we look to
In Section 7, and Section 9 is what applies to the newly appointed immigration judges. That's what you're saying?
Correct, Your Honor.
And that section does not have a 5-day
That's
requirement.
correct. And in fact, it says when a number becomes available, then a new immigration judge will be assigned. So the reassignment process begins once the number becomes available.
Well, opposing counsel said that that original IJ couldn't request a number if she had not made a decision.
That's correct.
What's
So
your response to that?
what happened there was that the original immigration judge reserved her grant, putting this case into a queue. However, that decision was never issued.
So she did make a decision.
It's a preliminary grant.
To grant, and that's how she got the number.
Correct.
And then it was put into a queue, but that doesn't mean it's the end of things, correct?
That is not the final order from an immigration judge, because as the memo states, a new judge is not bound by the initial judge's decision.
Right, and that's why the initial IJ said, in fact, a new judge, a newly appointed IJ may not grant your application, so you better stay out of trouble.
That's correct, Your Honor.
So if the first immigration judge was still on the job then, and the number became available, would your position be that, in this case, it's a female immigration judge, that she would have to have entered a decision within 5 days?
I would say it's an instruction, but it's not a mandate. It's not binding on the immigration judge or the court administrators. If we look to the language, it says the judge, once the number becomes available, the judge will revise the decision if necessary. It's not a must. So I would say in general, overall, the memo itself is not binding. It's just instruction and internal instruction for court staff and administrators on how to handle reserve decisions and make sure that they're keeping track of them so that they're not lost in the shuffle, so that they aren't being held reserved in perpetuity.
So is the government's view that this 1704 is purely an internal operating mechanism and that it's not legally binding on anybody?
That's correct, Your Honor. And in fact, various other circuits have held that the OPPMs, not including this one, are not legally enforceable and do not create any substantive rights. They don't provide any protections or remedies.
So if we agreed with your proposition, the case would be over?
That's correct, Your Honor. Regarding petitioners' contentions that the Carty doctrine applies, for the same reasons it doesn't apply, nor was there prejudice here. DHS on several occasions stated that they wanted to reserve appeal.
Well, the prejudice is hard to argue, because the prejudice is, he claims that if the decision was made in January or February, before he had his last violation, he would have gotten relief.
Well, his last violation was in February.
Well, then in January, when the number came up.
Well, we don't know when the number came up. The record isn't clear. The petitioner is alleging that DHS providing new background checks was an indicator that a number was available. But if we look to the memo on page 3, section 4, it states that OCIJ gives notice to the immigration judges that number becomes available, not DHS. So just because DHS ran a background check.
Does the record show when the number came up?
No, that's not clear.
Well, why did they reschedule it?
Because DHS ran background checks again and determined and found the new criminal violation. So DHS ran their initial background check. It could have been that OCIJ would advise.
Do they run background checks before they get the number?
That's correct. If it's coming up in the queue, they'll run the background check so that the case is ready to be issued once it comes up.
Okay.
However, the primary issue or the point there is that DHS does not give notice to the immigration judge. It's OCIJ. So even the background checks on January 14th would not trigger this 5-day instruction anyway.
Has any court, to your knowledge, concluded that 1704 is enforceable by?
The Ninth Circuit concluded that it wasn't legally enforceable.
Was.
That it was not?
That it was not. 1704 specifically.
Is that the only circuit to have addressed it?
This specific OPP, this specific one, yes, but other circuits have addressed various other different OPPMs, and they all come to the same conclusion that it's not
So
legally
there's
enforceable.
you don't know of any exception to that then?
No, Your Honor. If there are no further.
Anything further?
No, if there are no further questions, the government asks the court to deny
Okay.
petition.
Thank you. All right, Mr. how do I pronounce that? Moravec?
Moravec, Your Honor.
Moravec, I'm sorry, I apologize.
All right, Judge. I recognize we both have last names that people sometimes
Now, if I
might mispronounce.
start with the first syllable, I should be okay.
Thank you, Your Honor. To address a few things. First, factually, the visa was available on January 13th, 2023. In the department, I recognize DOJ maintains that queue, but they tell DHS we need to run the background checks because the visa is available. In their motion to recalendar, they acknowledged that they told the court, they acknowledged the visa was available and background checks were clear as of January 13th. And so
Where's that in the record?
that's in the record with the motion to recalendar, the March 28th, 2023 motion to recalendar from DHS. Second, there's no rule that internal memos are not binding on the court. The test that comes from McCarty and the following
Well,
jurisprudence.
why should we make them binding? In other words, there are all kinds of levels of procedures that institutions adopt, and some of them may be just bulletin board notices, some may be letters, some may be manuals, and some may be regulations. It seems to me that we have to draw a line somewhere as to what is an enforceable law and
Sure.
what's just an internal operating procedure which would not give others the right to enforce them.
Sure. The Supreme Court makes this distinction between general housekeeping procedures of agencies that they're not going to enforce versus regulations, procedures, policies that invoke substantive rights. And in this case, the right to due process, the right to have these policies, procedures.
This one wasn't a due process right. This was how to coordinate the 4,000 case limit with the ordinary docket of deciding cases.
I have to
And,
disagree,
and
and
it sort of integrated administratively, internally, how they were going to do that.
No, I have to disagree, and I would point the court to the preamble of the proposed final rule. When the agency adopted this rule, it said, quote, "An applicant who is advised the applicant's case is reserved because the applicant's case has not been denied would now have greater certainty in knowing the applicant likely will be granted cancellation." That creates reliance interest in these cases being told that they are granted. The second thing is
do you have any case that has taken these procedures and made them enforceable?
No, but the D.C. Circuit in Steinholt, which we cite in the brief, says that it deals with a case where there is the memorandum, the court acknowledges that memorandums can be enforceable, but in that particular case, it wasn't enforced because there was no prejudice, as the court, as this court suggested there
Your
is.
opposing counsel says there's a Ninth Circuit case, which admittedly I haven't read, that considers this very memo and says that it's not binding.
It does do that, Your Honor, and the court can read it in about 10 seconds.
Is that decision wrong?
No, the opinion is unpublished. It's about 3 paragraphs long, and footnote 1 of Laura says, we do not consider whether or not the memo addresses substantive rights. They simply sidestep the question I'm asking the court to consider here, and so it's not applicable. Moreover, all of the Justice Department memos that are published by DOJ ordinarily contain...
Not to belabor this, but
Yeah.
you think the Ninth Circuit decision is correct?
I don't know. It's unpublished. It doesn't have any recitation of the
Okay.
facts at issue there. I can't say one way or the other.
How about, we're told that other provisions of the OPPN have been held not binding.
So a few things. All of these OPPM documents, they're publicly available, and almost every single one, and I've gone through as many as I could tolerate going through, they contain a provision at the end, usually, that says some kind of disclaimer that says this OPPM document does not create any substantive or enforceable right. That's a notice to people who read it. You can't enforce it. This memorandum, 1704, contains no such provision. It falls 15 days after the regulation was adopted through notice and comment rulemaking, formal rulemaking, and reflects agency interpretation of that regulation going back more than 20 years. This is the standard practice. It is enforceable because the memorandum doesn't contain that language, and it reflects reliance interest in a substantive right. And therefore, Mr. Zelaya has the benefit of that being enforced, that on January 19th, 2023, a decision should have been made in his case. Because it wasn't, the prejudice falls, and as the court agreed, that prejudice is hard to argue against. The proper remedy here is to vacate the board's decision and send it back to the agency.
Okay.
Thank you.
Thank you. We'll come down and greet counsel and then proceed on to the last case. Children's Medical Center, and I guess we'll hear first from Mr. Banya.
Correct, yes. David Banya here, representing Sharice Parker. Good morning, Your Honors, and may
Can you
please-
speak up a little bit?
Sure. Good morning, Your Honors, and may it please the Court. Ms. Parker's appeal addresses several factors with respect to the district court's opinion. So the best place to start is always at the beginning with count 1. Ms. Parker pled a discrimination in violation of Title VII based on her status as a pregnant woman. And with respect to the prima facie case, the court concluded that Ms. Parker couldn't make her prima facie case. However, the issues that weren't in dispute were Ms. Parker's membership in a protected class. She was a pregnant woman at the time of her discharge, that she suffered an adverse employment action, termination. The court did conclude that she proffered enough evidence to show satisfactory job performance at the time of her discharge, but the court ultimately dismissed her claim based on her failure to meet the 4th prong which we have alleged, or asserted rather, that the adverse action occurred under circumstances that give rise to an inference of unlawful discrimination. It appears that the court, in its decision, went back and forth as to whether or not comparator evidence was required in order to meet that prong. Obviously, we asserted that it wasn't, and we proffered a lot of evidence that would allow a jury to conclude that her discharge was done under circumstances that would give rise to an inference of discrimination. For example, we proffered evidence of good performance and regular praise for her work performance by her supervisor. We proffered evidence that her supervisor recommended her to be a mentor to another employee seeking to enter into the specific field that Ms. Parker was in. We proffered evidence that she was never formally disciplined, she was never written up, she was never suspended, nor presented with any sort of corrective action form as required.
Part of your argument was that on the pregnancy discrimination on this last prong of a prima facie case, that the court categorically excluded her, the plaintiff's testimony, and that it should have considered that as part of the totality of the circumstances. I mean, is that, am I making that up?
No, you're absolutely right. Yes, you do recall that correctly. Yeah, the court said that some language along the lines that, other than her own testimony, she doesn't support doesn't support the fourth prong. But the court in that case.
So is your argument that that's the error?
Well, the error is, ultimately the conclusion that she didn't proffer enough evidence to meet that fourth prong, and the court's opinion sort of goes back and forth with respect to whether or not comparator evidence is required to meet that fourth prong. Ultimately, concludes that it isn't, but then faults us for not providing comparator evidence by stating something along the lines that Ms. Parker's case doesn't fall into an exception that wouldn't require comparator evidence. And again, our argument is the totality of the circumstances surrounding her termination would allow a jury to conclude and make a reasonable conclusion that that unlawful discrimination was the true motivation for her discharge, and not her performance issue, or her alleged performance issues. And I think that's also.
Does that go to the prima facie case, or does that go to a later finding regarding pretext?
So,
or does it go to both?
It goes to both, and that's another thing that I believe the district court sort of did, is segment evidence. That their pretext analysis is very light, and asserted that we didn't meet that. But the evidence is evidence, and evidence can be used to satisfy multiple elements of a prima facie case, or in a burden shifting scheme to satisfy the second burden. And it's particularly odd that the court would reach that conclusion, specifically when the court did conclude that she proffered enough evidence to allow a jury to conclude that her performance was satisfactory, and yet the defendant, their stated reason for her discharge was performance reasons. And so right out of the gate, the court concludes that a jury could call that into question, but then ultimately states that we failed to meet that burden. And so that's with respect to her count one. Like I said, there are a plethora of issues, but I'm happy to answer any questions relating to that.
Well, my question isn't as focused. This case involves, I just don't see where the employer is shown to have acted in any respect negative to Parker's pregnancy. The first time there was any issue about it is when she started to bleed, and she took 3 days off, and her supervisor told her that's fine, and she started to do a couple of hours of work during those 3 days, and the supervisor says, no, take rest. And after 3 days, she came back. Now whole incident, to me, is totally neutral. There's no discriminatory intent or disappointment. It's just the opposite. It seems to me the employer suggested take the rest that's recommended, 3 days rest the doctor recommended. The second time came up in the spring when she said she was told to only work 8 hours a day. And under the schedule she had, she only worked 8 hours a day. She worked 8:30 to 8 to 5:30 or whatever the hours were, and so that was non-consequential. Nothing other in the record reflects any response or discussion or notice or concern or praise about her pregnancy. And this case doesn't seem to be about pregnancy. I don't know what it's fully about. They did find her work unsatisfactory. They started the process way before that second incident and laying the foundation because they had to get approval and explain why they weren't going to hire her. She was on a probationary period. But the evidence of discrimination with respect to pregnancy, where is it?
So you really can't divorce the evidence of animus toward pregnancy versus the evidence of animus toward her.
Well, I'm asking you for animus. Animus usually is reflected in side comments or an email here or there or a quip.
Sure.
We have none of that here.
Well, we do have, when Ms. Parker did approach her supervisor and informed her that her doctor limited her work hours to 8 hours per day, her supervisor said, pregnancy is no excuse, you're a salaried employee, you're expected to work more. And we would also push back that there's a mountain of evidence that Ms. Parker did in fact work more than 8 hours a day. The set schedule, that's something in dispute, and that's certainly something for a jury to decide, because that's based on the supervisor's testimony.
Except they explained that her hours were, she was a salaried employee who had hours from 8 hours with a half hour off in the middle of the day, 8.5 hours with a half hour in the middle of the day. And those were her hours, and those were the hours she was working. She asked one time to go home early, an hour early, so it was recognized that she was in this hourly context expected to be there 8 hours a day. And her explanation was never rejected. Her explanation was basically said, well, that's your schedule. The doctor didn't countermand anything that she was already doing.
Well, that's just simply a fact in dispute, and it's right for a jury to decide.
I'm looking for the evidence, and we both have read that same part of the record. And the only other part that I know of that dealt with the pregnancy, well, there was the notification of pregnancy in November around Thanksgiving. There's nothing in the record about any reaction to that. So the first reaction was in December when she had that incident, and I thought the employer acted fairly positively toward her. Her situation at that point, but discrimination requires that showing that they made a decision. I mean, we have all the mechanisms of how to prove it and presume it and shifting burdens, but the bottom line is, was she discriminated against because she was pregnant, or was there some other reason? And the district court concluded basically there just wasn't enough here, I think.
Well, we would obviously dispute, and I think the evidence shows that. I mean, we can't weigh evidence at this stage or even at the summary judgment stage. There are numerous emails, plethora of emails, showing Ms. Parker turning in work product after this quote-unquote set schedule. And so there's also testimony from the corporate designees saying that she was expected to work more than 40 hours a week. There's a business record from the Hartford, the third-party administrator, where Sharice Parker tells them she was working 10 to 12 hours a day, 3 to 4 days a week, up through February. So there is evidence that she worked more than 40 hours. She asked for an accommodation based on her pregnancy, and she was told her pregnancy was no excuse. So I don't know what, I'm not I'm not sure what the court is finding is perfectly acceptable, but I would say that the ADA and Title VII say that
Well, I thought you were talking about discrimination. I mean, the ADA, I guess the question is, you're looking for an accommodation there. And the only two accommodations that I saw in the record was one to get off for 3 days because of her condition, and that was granted, and not only granted, but enforced so that she would have rest. And the second was that she only worked 8 hours a day, and that was her specified hours. So those were the two times an accommodation was requested. I'm not sure what she wanted. Did she say that she wanted something more than that at any point?
No, she said she wanted to work only 8 hours a day, and that was the order from her doctor, and so that was not granted to her. And this idea that there's a set schedule, and the only evidence of that is the supervisor's testimony. Meanwhile, there's countervailing evidence of her turning in work product well after this quote-unquote set schedule, as well as testimony from her saying that she worked more. There's a contemporaneous business record saying that she worked 10 to 12 hours a day, 3 to 4 days a week. And there's also testimony from the corporate designees stating that she was expected to work more than 40 hours a week. So that was an absolute denial of a request for an accommodation. And like I said, with respect to pregnancy
Well, there were two citations or statements in the district court's decision on failure to accommodate. One was that the plaintiff failed to show she could perform the essential functions of the job if given a reasonable accommodation. And second, that the defendant said it had done all it was legally obligated to do for the plaintiff, and that those simply weren't raised, and therefore they're waived.
Well,
Because you didn't address these alternative findings of the district court as to that claim.
So as to those claims, we didn't move for summary judgment, so we're not required to prove our case. We're only required to respond to their motion. They didn't attack those elements. They strictly attacked the element that she's not a person with a disability under the ADA. So we addressed that this idea that we have a burden beyond addressing what the person, the moving party on summary judgment, just finds no support in the law. They're the ones with the burden to show dispositive. It's a dispositive motion, dispositively, put dispositive evidence on the record that basically states that Ms. Parker could never, ever in a million years get a jury verdict.
I think the point here is that these, on that particular issue, these are alternative findings by the district court that you did not contest.
They were never raised, so that the court brought it up and said,
Yeah,
I would argue that they waived
they're
those
in the
elements.
court's order. Where do you address them here?
I'm sorry?
They're in the court's order, so where do you address them here?
Well, I believe we addressed those in the opening brief, and I believe it is thoroughly addressed right at the beginning of our analysis on the court's holding on count 2. And I believe it may be a footnote on.
Well, you can tell
Okay.
us that when you come back.
I was going to say, you're over your time now, but you have rebuttal, so you can address that if you wish at that point.
All right, thank you, Your Honor.
We'll hear now from Mr. Tucker.
Good morning, Your Honors. Jim Tucker for the Equal Employment Opportunity Commission. The Commission's participating here mainly to address the District Court's analyses as to the questions of substantial limitation and the request for reasonable accommodation. But if I could, before reaching those issues, just note, following up on your question, Judge Niemeyer, regarding the evidence in the record regarding a request for an accommodation beyond what she'd been provided. At JA 126 and 500 through 501, there is evidence discussing how it was that Ms. Parker testified that she worked an 8:30 to 5 shift, 5 days a week, but that she was also frequently required to work 10 to 12 hours a day. So it was beyond that shift. She did present evidence that she worked beyond more than a 40-hour week. And just to note that the event that gave rise to the argument about whether or not she was accommodated, that the week after her doctor provided her the limitation of no more than 8 hours of work, had already worked a full 8-hour day, and at that point, when her supervisor contacted her and asked her to perform more duties, she noted that she'd been limited, and she provided that doctor's note and explained that due to her pregnancy, she was limited to working no more than 8 hours a day. So there is evidence in the record addressing that point. But to come back again to the question of substantial limitation, and let's start with that. Regarding the district court's analysis, our concern was just again primarily to identify that it appears that the district court in this case relied on standards that had been preempted and pushed out by the ADA Amendments Act of 2008. The court relied on and identified as guidance in addressing whether or not Ms. Parker was substantially limited to district court decision, the Wanasoo decision, which itself references this court's 2002 decision in Pollard and identifies the elements that at that time controlled the question of whether or not an individual was substantially limited in a major life activity. And that is no longer good law. It wasn't good law at the time of this district court decision. It's not now.
Did the district court address the current law at all?
She mentioned that, and she identified that it is still a requirement under the newly amended statute that the individual must show a substantial limitation. And no one quibbles with that. That part of the statute wasn't changed. What was changed was the standard underneath that it showed, that is required to show and meet that limitation.
So the district court acknowledged the substantial limitation, but applied the wrong standard to analyze it.
Exactly,
based
Your
on
Honor.
old law.
That's our position, Your Honor. Again, this court in Summers went through very thoroughly and described the correct standard to apply post-amendment to disability claims regarding substantial limitation in particular. And the district court mentioned Summers for the general proposition that disability discrimination is illegal, but never mentioned it again in its analysis. So we'd again suggest, following as our argument, our brief is that Summers is an excellent guideline for how courts should follow and apply the substantial limitation analysis. Similarly, turning to the question of a request for reasonable accommodation, the court determined that Ms. Parker had not made the request for reasonable accommodation, focusing on the incident I just referenced when Ms. Parker was asked to work additional hours. It was, I believe it was late January 2019, 1 week after she'd been given her limitation by her doctor. And in analyzing that, the court made mention of this court's decision in Kelly, which again described.
She requested it in February though, right? February 22nd?
Oh, she actually made 2 requests for accommodation, Your Honor. One was in orally to Ms. Viad directly, a week after she received the note from her doctor. And then there was a second request in writing to the Hartford, which is CNMC's third-party provider of benefits. And they have also a mechanism to contact the Hartford to make a request that way. And she did that as well. That was after just factually, after Ms. Viad had sought advice from HR on how to proceed with terminating Ms. Parker. We focused on the earlier request because that's the one the district court focused on, since that was more relevant in the time frame, because Ms. Parker would have needed to have engaged in protected activity prior to the employer taking adverse action against her. This is all in the context of a retaliation claim. But again, in its analysis of whether or not Ms. Parker had properly requested a reasonable accommodation, the court cited this court's Kelly decision, but didn't explain how it was that Ms. Parker failed to meet what in Kelly this court describes as a very light and non-burdensome process by which the individual needs only to request an accommodation by asking or identifying to the employer that they need some assistance with their work and that it's related to a disability. So long as there is a logical bridge between those two, the individual does not need, per Kelly, the individual does not need to
Okay.
I have
go any further.
one question before you sit down. Do you have anything to say about the fact that the district court required appellant to provide comparator evidence, or appeared to require that?
We did address that in our brief, Your Honor, and again, it appears that what she was required to do is, well, the district court said that comparative evidence was not required, and when it identified, again, what Ms. Parker had presented, her testimony regarding her own experience with Ms. Viad and how that experience suggested the circumstances around her termination suggested discrimination. The court dismissed it out of hand simply because it was presented in her own testimony. And as this court's recognized repeatedly, that an individual's own testimony isn't necessarily dispositive as to whether or not it has any probative value. There may be other infirmities with testimonial evidence, but simply because it comes from the plaintiff themselves is not a reason for discounting it.
Okay, thank you.
Thank you, Your Honors.
All right, let's see, who do we hear from next? I guess Mr. Johnson?
Thank you, Your Honors, and may it please the Court, Jeff Johnson for the appellee in this matter, Children's National Medical Center. In this case, the District Court appropriately granted summary judgment on plaintiff's claims of failure to accommodate, discrimination, and retaliation, where the undisputed evidence in the record demonstrated only that the plaintiff was pregnant, that she had performance issues that arise both before and after she disclosed her pregnancy, that the plaintiff went out on a 3-day period of bed rest during which she was accommodated by Children's National and allowed to rest, and then returned to work in a full-duty capacity, at which time she was terminated for the same performance issues that arose before she ever went out of work. In light of that undisputed record, the District Court here appropriately granted summary judgment and used the appropriate legal standards in doing so.
So you don't think that the district court used pre-ADAA authority to support the district court's opinion?
I don't, Your Honor. I recognize that the District Court did take guidance from several pre-ADAA opinions, particularly Wanasoo and this court's decision in Brockman. But I think that there are several points from those decisions that do remain relevant, which is particularly that pregnancy alone is not a disability. This court has said that a pregnancy-related impairment that's abnormal may be a disability, and that remains good law, notwithstanding the fact that the ADAA lessened the standard to prove a substantial limitation. And the District Court here, while it pointed to Wanasoo and Brockman as relevant guidance, it did not say that it was applying that substantial limitation standard. And the District Court analyzed the evidence in this record to determine that the plaintiff was not substantially limited either in her ability to work or to reproduce, which were the two theories proposed by the plaintiff in this matter. Now, turning first to the prima facie case, which Mr. Banya addressed at the outset, plaintiff doesn't dispute that she lacked direct evidence of discrimination and was therefore required to proceed under the McDonnell-Douglas burden-shifting framework. Now, under that framework, the plaintiff was first required to create an inference of discrimination. And under this court's precedent, that's most commonly done via comparator evidence. And in fact, the plaintiff in this case pled comparator evidence as her theory of liability in two of her pleadings, both her complaint and her amended complaint, as reflected in pages 25 and 95 of the joint appendix here.
But the District Court, I don't think the District Court felt that she was bound by that she could make this other showing for that fourth element.
That's correct, Your Honor, but plaintiff emphasizes the District Court's analysis of comparator evidence.
Right,
and
I understand that.
The point being it was brought about by plaintiff's own pleading. But plaintiff is right that this court has held, as has the Supreme Court, that the prima facie burden is flexible. It's not rigid, it's adaptive to varying factual circumstances. But to Judge Agee's earlier point about whether or not the evidence plaintiff was providing went to pretext or the prima facie case, plaintiff skips a step in the process. Plaintiff goes right to questioning the believability of the employer's stated reason for terminating her well, she cites the case law talking about how the prima facie burden is not onerous and is adaptive to various factual circumstances. She doesn't cite to any iteration of the prima facie case recognized by this court or any others that would permit the plaintiff to proceed right to attacking the believability of the employer's stated reason. And I think the Supreme Court's decision in both Reeves and Hicks demonstrate that the plaintiff needs to have a combination of the prima facie case and evidence of pretext to meet their ultimate burden under the McDonnell-Douglas burden shifting.
Here's my question on both of those points, which comes from page 812 of the record. And as I read that concluding sentence of the first paragraph, you could read it to say that the district court categorically excluded the plaintiff's own testimony in consideration for the last element of the prima facie case and not quite as clear also on pretext. And I thought that the court was required to consider it, and it couldn't exclude it per se from its analysis. That's what I'm asking the question about.
Yeah, Your Honor, and I think the district court's opinion is subject to that reading. I think there's certainly language that would indicate that the district court said the plaintiff's own testimony is not competent or admissible on that last prong, on that prong of the prima facie case. But I think the real issue in this case, and that this court can find based on the de novo standard of review, is that there was no admissible evidence in the record to that effect. Plaintiff argued in her pleadings that Ms. Viad and Ms. Viad as plaintiff's supervisor, made various statements that were indicative of discriminatory animus, that her behavior changed once the plaintiff had disclosed her pregnancy. But that language was taken directly from the plaintiff's pleading, and it's well established that the plaintiff can't just rely on her pleadings to defeat a properly supported motion for summary judgment. And in fact, if the court looks to the characterization of Ms. Viad's behavior, it's in fact true, and plaintiff would have the court believe, that Ms. Viad remained complimentary of the plaintiff right up until the day that she was terminated. So in light of that evidence, which
I'll grant you this is not the strongest plaintiff's case that I've ever seen. But there is this one statement in answers to interrogatories on page 364, where it says Parker called Viad and showed that she needed to limit her hours. Parker informed her that she had a doctor's note. In response, Viad said it didn't matter if Parker was pregnant because she was still a salaried employee and her pregnancy was no excuse. Is that not sufficient to get to the prima facie case?
Your Honor, I would say no, because Title VII would require, outside of the accommodation context where an employer has to make decisions with specific regard to a protected characteristic.
I'm not worried.
Right.
Leave the accommodation stuff out of it.
Sure. Under Title VII, the employer is required to make employment decisions without regards for the employee's protected characteristic. So if the supervisor is saying, I'm going to hold you to these particular employment standards, notwithstanding the fact that you're pregnant, the employer is actually doing what Title VII would require. Title VII is not an accommodation statute and would require that an employer make decisions without regards to those types of protected characteristics. And as it relates to the characterization of Ms. Viad's behavior, as I was saying, plaintiff alleges and argues in her briefing that Ms. Viad remained complimentary of the plaintiff's work right from the time that she was hired until she was terminated. So in light of that, this court has an at best ambiguous record, and without comparator evidence, is left in a spot of making subjective value judgments about a supervisor's conduct, which this court noted in the Lang v. Federal Express decision it seeks to avoid. Plaintiff needed that comparator evidence under the circumstances of this case because she had no other basis to create an inference of discrimination without proceeding right to pretext. Now, I'd like to address the issue of disability, which Mr. Tucker addressed as well. The district court also held under these circumstances that the plaintiff was not subject to a substantial limitation of a major life activity. And I want to be clear as to what was disputed and litigated below. Children's National doesn't dispute that the plaintiff was pregnant. Children's National doesn't dispute that she had an impairment related to that pregnancy, i.e. uterine fibroids. Children's National only argued that the plaintiff was not subject to a substantial limitation of a major life activity. And the only limitations that were before the district court were this 3-hour period, or this 3-day period of bed rest during which the plaintiff was accommodated, and then a later request to limit her work hours to 8 hours per day. Now, neither plaintiff or her amici provide any support for the proposition that a plaintiff who is limited to 8 hours of work per day, or even 40 per week, is substantially limited in their ability to work. And as it relates to the 3-day period of bed rest, I think plaintiff's own testimony on this point is notable, as Judge Niemeyer pointed out. The plaintiff testified that while she was placed on this period of bed rest, she tried to work and wanted to work and faulted Children's National for telling her to do as her doctor ordered, which was stay on bed rest. Now, so in light of that fact, the court only had those two issues, and it had no basis to assume, based on the fact that the plaintiff was limited to 3 days of bed rest and had this later 8-hour limitation, that the plaintiff was substantially limited in her ability to work. And as it related to the major life activity of reproduction, there was also nothing in this record to indicate that plaintiff's ability to procreate, whether it be to get pregnant, to carry a baby to term, or to give birth, was substantially limited in any way while she was employed by Children's National. But even if the court disagrees with that assessment of the record, it can still affirm the district court because the judge also determined that Children's National did everything that it was required to do as it related to the plaintiff's accommodation request. And on that point, it's important to note that there is no evidence in this record that plaintiff's 8-hour limitation was caused by her uterine fibroids. The only evidence in the record is a doctor's note indicating that because of pregnancy, the plaintiff is limited to 8 hours of work per day. And this court has been clear in the Brockman decision, which remains good law for this point, that the status of being pregnant alone is not a disability under the ADA. And it's well established that an employer only has to accommodate a plaintiff in ways that are related to their disability. So if the plaintiff was limited to 8 hours of work per day because of her pregnancy alone, an employer under the ADA has no obligation to accommodate that limitation. And as Judge Niemeyer pointed out earlier, the plaintiff was in fact accommodated when she was on this 3-day period of bed rest when her supervisor insisted that she rest and do as the doctor had ordered.
I'm still concerned about the district court's reliance on pre-ADAA authority. Where, is there some place where the district court actually analyzed using the appropriate authority? Post-ADAA?
Your Honor, the judge did cite to, if my recollection serves me right, the statute and applicable regulations regarding the substantial limitations standard as it exists post the Amendments Act.
Right, and I think that's what opposing counsel said. The district court acknowledged the standard, but then analyzed the standard using outdated authority, which you cited to earlier as the district court found guidance in that old authority.
Right, and I think my point was, Your Honor, that I think the district court took guidance from those decisions for reasoning that still remains good law. On the point of substantial limitation.
Okay, so you're saying that, because it's, the district court substantially quotes the old law, and you're saying the portions that the district court quoted and took guidance from remain good law somehow.
Your Honor, there are very lengthy block quotes in there, so there may be some portions there where
pages of block quotes.
You're correct, Your Honor. And so I can't sit here and represent to the court that there's not language in there that may be indicative of a pre-Amendments Act substantial limitation standard. But if you look at the actual analysis by the district court of the facts of this case.
So when the district court analyzed the facts of this case, which post-ADAA authority did the district court find guidance in?
It had cited to the regulations, Your Honor, so I would say certainly the statute and regulations, but I will also say that the district court's reasoning is entirely consistent with the Post-Amendments Act substantial limitation standard. Particularly, the court noted that there was no evidence in the record to corroborate that the plaintiff was substantially limited in her ability to reproduce, whether under a pre-Amendments Act standard or a post one. There was just no evidence in this record that the plaintiff was limited in that regard. And even as it relates to the 8-hour limitation, plaintiff and her amici don't cite to any support from any authority that a limitation of 8 hours of work per day or 40 per week is a substantial limitation of a major life activity. The EEOC's regulations are clear that we need to compare a particular plaintiff's substantial.
Opposing counsel said that there was testimony from the corporate designee saying that she was expected to work more than 40 hours a week. Is that accurate, or what's your response to that?
Well, Your Honor, I think that gets to whether or not she was in fact denied an accommodation, but on that point, the corporate designee's testimony was simply that salaried employees sometimes are and sometimes aren't required to work more than 40 hours per week. They're hired to do a particular job. The corporate designee never provided any testimony about whether plaintiff in particular was required to work in excess of 8 hours per day. And the plaintiff's supervisor, the one who would have knowledge of the plaintiff's particular job requirements, testified that she wasn't subject to that and she was never required to do so. And I know.
So the corporate designee you're saying was just speaking in general that salaried employees are required to work sometimes more than 40 hours a week, but the designee's response was not specific with regard to appellant here?
That's correct, Your Honor. The designee's response was in regards to salaried employees and what sort of expectations are placed on them. And I'm paraphrasing the testimony, but it's specific to the job. It may be that they work less than 40 hours, it may be that they work more, but there was certainly nothing in the record that from the corporate designee that Ms. Parker in particular works in excess of 40 hours per week. Now, I know there was some reference to the emails in the record about Ms. Parker working in excess of 8 hours per day because she was sending emails late at night. And I know the plaintiffs provide a lot of emails in the record to try and corroborate that point. But I would only point out that there are only 3 emails that post-date the plaintiff's alleged request for this 8-hour limitation. And of those 3 emails, in 2 of them, the plaintiff, unsolicited, is sending work-related correspondence to her supervisor without any indication that she was required to do so or that that was some sort of continual shift of the plaintiff till 10, 11 p.m. at night. And then in the 3rd email, the supervisor asked the plaintiff a question at 10 or 11 a.m. in the morning, and the plaintiff inexplicably waited until 11 p.m. to respond.
That was the point I was going to make as well. I think that emails late at night might just indicate she didn't actually get her work done during her 8 hours, and that 3rd email seems to indicate that she's doing something else with her time during those 8 hours.
Yeah, there's nothing in the record to indicate what plaintiff was doing earlier in the date on those occasions, so I would submit that the most the court can infer from those emails is that if anyone disregarded the plaintiff's doctor's orders, it was the plaintiff herself. You know, the Children's National can't stop the plaintiff from sending emails late at night if she's so inclined, but there's certainly no evidence in the record that Ms. Viad made her do that as some sort of requirement of her job or any sort of typical shift that she was expected to work. I'd like to lastly address the issue of pretext, which this court can get to and address if it establishes or decides that the plaintiff met the elements of the prima facie case. Now, plaintiff attacks the district court's ruling on the issue of pretext on 2 bases. The plaintiff first argues that she was held to a pretext plus standard and then argues as an evidentiary matter that she did in fact provide admissible evidence of pretext on this record. Now, regarding the former, I think it's important to clarify what the pretext plus standard is, and I think once that's clarified, it's fairly clear that the plaintiff was not held to any impermissible burden. And this court, and including several other circuits prior to the Supreme Court's decision in Reeves, had decided that a plaintiff, in order to meet their burden to prove intentional discrimination, was required to both meet the elements of the prima facie case and then provide separate or additional.
Just so I'm clear, your argument here is along the lines that if we assumed without deciding that the plaintiff met her prima facie case under Title VII, we then go to pretext, and that's what you're arguing now.
That's correct, Your Honor. It's an argument in the alternative. So should the court decide that the plaintiff didn't meet her initial burden to prove the prima facie case, it can end there. But if the court does decide that she did meet that burden, it should still affirm in light of the district court's reasoning and analysis on the issue of pretext, which is also part of plaintiff's burden under the McDonnell-Douglas burden shifting framework. And under that framework, the district court cited to an earlier district court opinion in Ramos v. Molina for the proposition that the plaintiff had the burden to prove both that the employer's stated reason for the employment action was not believable and that the true reason was intentional discrimination. And the plaintiff points to that as evidence that she was held to a pretext plus standard. But I think it's important to note that Ramos v. Molina was decided nearly 10 years after the Supreme Court's decision in Reeves, which got rid of the pretext plus standard, and that this court later affirmed Ramos v. Molina in an opinion which also noted that the plaintiff was held to that burden and cited extensively to Reeves. So based on that fact, the mere fact that the district court had cited to Ramos v. Molina certainly didn't hold the plaintiff to a pretext plus burden. Now, I know my time is limited, and plaintiff has a lot of evidence in the record that she claims to be evidence of pretext, but I'll submit to the court that much of that evidence is pure speculation in second-guessing Ms. Viad's analysis and assessment of the plaintiff's performance. And just to give an example, plaintiff speculates that Ms. Viad at one point in time in vetting the termination decision with Children's National's HR department used the term loopholes. And plaintiff speculates and guesses, well, Ms. Viad must have meant, you use that as a pejorative term, and that's indicative of discriminatory animus. But there's no evidence in this record to that effect, as there is no evidence regarding plaintiff's other assessments of pretext that this was a lie or a cover-up for intentional discrimination.
All right, thank you, Mr.
Thank you, Your Honors.
Johnson. All right, I guess we have Mr. Banya.
Thank you. I'd like to address, whether or not Ms. Parker had submitted enough evidence to demonstrate that she was a qualified person with a disability. And I do believe the evidence is overwhelming here, that she certainly meets that prong of her ADA claim. She submitted medical records and testimony of a fibroid rupture, severe bleeding, an ER visit, 3 days of physician-ordered bed rest, time off of work, evidence of 5 additional fibroids that she had in her uterus, one impinging on the wall of the uterus, evidence that she was placed on medical monitoring to assess the viability of her fetus, evidence that she required spontaneous abortion precautions. All that is in the Joint Appendix 430. Evidence that she was diagnosed with uterine fibroids affecting pregnancy. That's the official diagnosis. Evidence that she was diagnosed with a high-risk pregnancy. Evidence of a subsequent vaginal bleed that required medical attention and time off of work. And evidence of uterine pressure due to fibroids requiring her to wear a brace and affecting her ability to walk. There's no doubt, from our perspective, that's certainly enough to raise or enough evidence to demonstrate that affects her major bodily functions of her reproduction. And not only that, it also is evidence of an episodic condition, and that's something that the district court simply did not address. We argued that in summary judgment, that that her condition does qualify under the ADA under episodic conditions, and it just went completely unaddressed, and nobody's ever addressed it, and it certainly qualifies as a condition. She had fibroid rupture. She already had 2 episodes of vaginal bleeds, and she had 5 more fibroids in her uterus on top of that. And so, the ADA, while there isn't a lot of case law with respect to episodic conditions, the plain language of the statute is pretty clear. It's an impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. And so when she has these vaginal bleeds, both times she had vaginal bleeds, she had to take time off of work, and she had to go seek medical attention. And that, coupled with the fact that she has a diagnosis of 5 other fibroids in her uterus, she is absolutely under that theory of disability, has proffered enough evidence to meet that prong that she is a qualified person with a disability. And with respect to the 40-hour limitation, while the Children's National argues that doesn't show a substantial limitation, that's pre-ADA mentality. If a doctor orders you to work 8 hours a day because if you don't, you might suffer an episodic condition such as a fibroid rupture or a vaginal bleed, which would make you disabled when active, then that's certainly an accommodation that should be explored, and the interactive process should take over at that point as well. With respect to pretext evidence, we submitted a lot of pretext evidence, and while they call it speculation, we would call it reasonable inference in the totality of the circumstances that a jury could easily conclude. The fact that the supervisor went to HR within 2 weeks of Ms. Parker asking for an accommodation, seeking to terminate her, but still wanted to keep this alleged poor performer working for her and doing work for another 6 to 8 weeks just defies common sense business logic to want to hold on to a poor performer. And so we have temporal proximity coupled with the fact that she wanted to hold on to her, which would lend to the what we would say a reasonable inference that it really wasn't performance, but it was this pregnancy and this pregnancy-related accommodation that the supervisor didn't want to accommodate. We have shifting stories relating to performance. They can't get their story straight. Was she fired because the people that she was teaching, she was a corporate trainer, were failing their assessments? Well, they abandoned that. That's what they said at the EEOC. That's what they said early in discovery. When you kick the tires on that claim, they had to abandon that, and then they came up with a more sort of specious argument that students in her class weren't prepared adequately. And so that's sort of something that's subjective, and the evidence of that is an unknown declarant to the supervisor from another manager saying that their subordinates weren't well prepared for the assessment. And so that shifting story is obvious evidence of pretext, and I think somebody could easily reach the conclusion, a jury could reach the conclusion that unlawful discrimination
your time's up
is afoot. Thank you.
Yeah, we'll come down and greet counsel, adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.